after we finished recording, the court released an order on the shadow docket in the foreign aid case. This is the case challenging the administration's freezing and cancellation of foreign aid funding that Congress has appropriated to be distributed by the U.S. Agency for International Development and the State Department. But we refused to let the court win, so we sat back down to record an update.
Okay, so Leah mentioned this is a case about foreign aid funding and USAID. And if you're thinking, wait, I thought SCOTUS actually already declined to pause a lower court order in this exact case, you would be right. But as we tried to convey at the time, and this goes back quite a few months, that initial win was honestly probably overplayed. So previously, the matter went up to SCOTUS on an order to enforce a temporary restraining order. So back in February, after the district judge in this case, Judge Ali, entered a temporary restraining order, finding that the freezing and cancellation of all of this foreign aid was likely illegal, the plaintiffs argued that the defendants were not complying with that restraining order. You know, at the time, seemed really shocking. Now it is just an ordinary day at the Department of Justice. So the judge granted the plaintiff's motion to enforce the TRO, basically, issuing a stronger directive like you must comply by a certain deadline. The government took that case up to SCOTUS, and the Chief Justice entered an administrative stay, and the court didn't act on that stay application until after the deadline for enforcing the TRO had passed. But at that point, the court did deny the request for a stay, so ruled technically against the government, but it was basically moot at that point.
Right. So this also was the case that led everybody to say Amy Barrett was a moderate who was going to save the republic. Right. No joke. That's part of why we have been so anti that narrative. Anyways, so after the Supreme Court denies the stay application in the order to enforce the temporary restraining order, the case goes back down to the district court. And the district court subsequently entered a preliminary injunction that was reviewed by the D.C. Circuit and then modified by the district judge who entered another preliminary injunction that this one, the D.C. Circuit, let stand. And that one, this later preliminary injunction, that is now the district court order that the Supreme Court has stayed. And meanwhile, in the interim, that is between the time the court declined to rule against the government on that motion to enforce the TRO, and now the government has been able to drag its feet and stonewall paying over its obligations.
And paying up billions of dollars of obligated funds. So that's how we got to Friday night. And on Friday night, the Supreme Court granted the government's application to stay, but on a theory that the government hadn't even really pressed and that the lower courts had actually amended their opinion to ensure they didn't reach. We've talked about this previously, and we're not going to rehash it. But basically, the theory that the court seemed to embrace here is that the Impoundment Control Act, this federal statute passed to constrain president's ability to cancel funds after Nixon and Congress got into a war over Nixon's attempts to do just that, that this statute designed to respond to Nixon's overreach somehow prevents plaintiffs from litigating an otherwise valid APA claim under another federal statute that could require the expenditure of funds wrongfully withheld.
We're going to say that again just so you can appreciate how nutso it is. The Supreme Court appeared to embrace the theory that the Impoundment Control Act, a law specifically passed to restrain the executive's power to decline to spend appropriated funds, apparently bars plaintiffs from challenging the executive's power to decline to spend appropriated funds on grounds other than the Impoundment Control Act. This is nuts. It is absurd. It makes the Impoundment Control Act, which again is designed to prevent the president from canceling and rescinding funds, into a shield that somehow renders unenforceable other laws that might also limit the president's authority to decline to spend funds.
So that is the basis on which SCOTUS granted emergency relief and blocked the lower court order. It's, again, a ground on which the D.C. Circuit panels amended their opinion to make clear that they were not saying, they were not even reaching. Now, SCOTUS did something kind of interesting in its little short order for the majority, emphasizing that this was just their preliminary determination. They said, quote, "This order should not be read as a final determination on the merits. The relief granted by the court today reflects our preliminary view consistent with the standards for interim relief." So a couple of things. nice try to sort of turn down the temperature. No one is buying that this is just not a big deal, tiny, temporary, preliminary. Who knows what's going to happen down the road? This is one of these bells that cannot be unrung. But I do think that it is revealing that the court saw the need to include that sentence because clearly the public criticism is getting to them, and it should be. But regardless of that effort to kind of, ratchet down the significance of this order, it's impossible. The order, I think, very clearly broadcasts this breathtakingly broad understanding of the president's foreign affairs power, because the court does say, there's a very good chance the executive branch has made a preliminary case, at least, that not granting this stay would unduly infringe the executive's foreign affairs power. So at least they want to make clear that if a future Democratic president wants to spend a lot of domestic funds, this order does not give them cover to do that. So there is that effort to sort of link this just to the president's conduct of foreign affairs. But obviously, I think an enterprising president can connect just about anything to the conduct of foreign affairs.
At least if they're Republican.
At least a Republican president. Thank you for that very important qualification. But they basically say, on the record, the asserted harms to the executive's conduct of foreign affairs appear to outweigh the potential harm faced by respondents.
Yes. Forcing the executive branch to comply with a law that has been around for decades is a greater harm than is denying millions, billions in foreign aid to programs that depend on it and peoples whose lives and health may depend on it as well. This court's view is that President Trump and his administration are irreparably harmed when they have to comply with laws that have been around for decades, if not longer, and that no one may have even thought to challenge up until now. Like, the unitary executive is so unitary, it unites all of Congress's Article I powers, like the power of the purse, in the presidency now, at least a Republican presidency. As Justice Kagan described this case in her dissent, this challenge is to, quote, a presidential usurpation of Congress's power of the purse.
Right, because on one side of the balance is presidential authority to do whatever the president wants. On the other side are not only the recipients of this aid Congress has already appropriated, but also Congress. Literally, that's the other thing on the other side of the balance. And the court is like, seems pretty clear the president's interests are stronger here, but with one unconvincing sentence of support. And I think that's part of what is making Justice Kagan in dissent just so furious, is just how little consideration and care has clearly gone into this unbelievably consequential order. So Justice Kagan dissents once again. She is joined by the other two Democratic appointees. And she actually notes that even if you're somewhat sympathetic to what the majority seemed to have concluded based on what we said. So there is this one statute, and maybe that statute's supposed to be the whole game, and thus plaintiffs can't bring other kinds of challenges when the Impoundment Control Act is supposed to kind of occupy the field. Turns out the Impoundment Control Act itself has in it a pretty strong non-preclusion provision. So the statute itself says, quote, "Nothing contained in this act shall be construed as affecting in any way the claims or defenses of any party to litigation concerning any impoundment." Okay, so she explains in plain English that nothing in the Impoundment Control Act, or ICA, affects, in any way, other kinds of claims that relate to impoundment. The statute refutes the conclusion reached by the majority. And she
Extreme textualism.
Yes. She also just scorches the majority's assessment of irreparable harm, writing that basically what the executive complains about, this is intolerable, is, quote, "just the price of living under a constitution that gives Congress the power to make spending decisions through the enactment of appropriations laws. It cannot be heard to complain, as it does here, that the laws clash with the president's differing view of American values and American interests. That inconsistency is not a cognizable harm to be weighed in the equitable balance. It is merely a frustration any president must bear." And then this latest installment means that the number that we read up top is already out of date. So the Trump administration is actually now on, I think it's a 21-win streak on the shadow docket.
Yikes. If they are going to make, small motions toward interim emergency docket reframing, I'm just going to put another proposed name on the table, which is the just the tip docket. They give us just kind of a little reasoning. They insist the country's not getting fucked, but the country is getting fucked. As they say on RuPaul's Drag Race All-Stars, and that's the tea.
Just one more thing about Kagan, can I just say that just the tip is amazing, but it's also I don't know that it has been that I have seen before a justice be as explicit about what is happening inside the court. She is like, we haven't even talked about this. We haven't gone to conference. She says that in 3 weeks we're going to be deciding way smaller cases where we get briefs, people make arguments, we sit down and discuss this stuff with each other. And she is saying literally none of that happened here. We got like some papers filed and like these guys decided like thumbs up, president wins without really saying more. And that's apparently just how this court does business now. And it is outrageous.
Yeah, no, she broke the fourth wall like Justice Jackson had previously on an earlier shadow docket matter, accusing the Supreme Court of just wanting to give the Trump administration an early win in some litigation in order to kind of balance out the scales. So, yeah, that is apparently the Supreme Court now, ladies and gentlemen.
Yeah.